Hi guys, it's Gabriella Augustinelli with Berardi Immigration Law, and wow, today is a big day. There's a lot of things to go over after yesterday USCIS published a notice of proposed rulemaking largely concerning the H-1B category, though it can be applicable to other categories. That's what we are going to focus on in our discussion today. So this new rule has a lot of moving parts to it, so let's go through them. I normally can talk off script, but there's a lot to go over today, so I brought my notes. So this notice of proposed rulemaking is called Modernizing H-1B Requirements, Providing Flexibility in the F1 Program, and Program Improvements Affecting Other Non-Immigrant Workers. And similar to most notices of proposed rulemaking, there is a 60-day comment period that we all have to chime in with our thoughts on these developments. So there's what I would describe the good, the bad, and the ugly about this. So why not rip off the Band-Aid and start with the ugly right now? And what this is generally going to center around is how USCIS is proposing to review H-1Bs at the most granular level, which is determining, is something really a specialty occupation? Is the offered position with the company in the U.S. meeting the definition of specialty occupation, which, let's recall, really indicates whether or not somebody has a bachelor's degree or higher in a specific specialty or its equivalent. Now, in a move that has surprised a lot of people, when drafting this proposed rule, the Biden administration has pulled in a lot of language that came directly from Trump's proposed rule in 2017 that also seek to greatly limit somebody's eligibility for H-1B status. And specifically what we're talking about here is that they have added the language stating that to qualify as a specialty occupation, the position must require a U.S. bachelor's or higher degree in a directly related specific specialty or its equivalent. Now, why is this a big deal? Well, let's look at this crazy statistic. Did you know that more than half, 51%, of U.S.-born individuals and 18% of temporary visa holders who work in computer occupations have a degree other than a computer science or electrical engineering degree? This is according to a 2021 survey by the National Foundation for American Policy. So what does this mean? That there's a ton of people walking around this country holding STEM fields, working in a computer occupation, that don't have a degree that is directly related to their occupation. These folks, if we are going to strictly read and interpret the words of this policy memo, are saying that, hey guys, you're no longer going to qualify as being among the individuals who holds a specialty occupation, and therefore you are foreclosed from being able to obtain this work permit. Now, we don't know how closely the administration is actually going to follow this language, but on the offset, it's something that we can be hugely concerned about. If your degree is not directly related to the occupation that you will have a job offer in, well, you're not going to get that H-1B. That's a huge deal. Another thing that the government has mentioned in this section is that if somebody has a general degree, such as a business administration or liberal arts degree, without further specialization, that is insufficient to qualify for an H-1B position. Okay. So what's another thing that we'll call the bad or the ugly under this, in my humble opinion, would be that in matters involving staffing, outside staffing, or third-party site placements, the government is going to interpret whether the position is a specialty occupation not by what the petitioner considers to be a degree requirement for the position, but what the third party requires to be a specialty occupation, or whether to be what they determine to be the required degree for that position. So for an individual who has multiple third-party work sites, this can become very confusing very quickly. We'll have to see how this plays out. Well, let's switch to the good. That's pretty much the worst of what we're going to see on the bad. As you can imagine, that could open itself up to lots of litigation in the future. It has been successfully litigated in the past and was not able to move forward. So we're going to have to just follow this as it plays out in real time, if in fact the final rule does go forward. Okay, so let's talk about the good. The first good thing that we want to talk about is this concept that normally does not mean always. And for those of us who practice a lot in the H-1B sphere, we know that this language is talking about people who are applying for an H-1B predominantly in the computer programmer field. Now, the reason why this comes up in the computer programmer field is because Department of Labor publications like the Occupational Outlook Handbook indicate that for somebody to become part of this occupation, normally a bachelor's degree is not needed. And because of that, the government in the past has interpreted this to mean that it's always the case that you don't need a bachelor's degree, and therefore you can't qualify this position as a specialty occupation position. Well, that's simply not true. A lot of employers do require the attainment of a bachelor's degree in a specific field in order to be a computer programmer. And what this policy guidance does is it indicates, or it would indicate, that just because the OOH or another, ONET or another government document says that a degree is not typically required, it doesn't mean that it's always not required, and basically give a chance to allow the petitioner to explain why an occupation that doesn't always require a bachelor's degree can actually fit the bill. Okay, so another good thing that the government wants to do with this proposed rule is to codify that adjudicators should generally defer to a previous prior determination of whether somebody met the eligibility criteria for a particular benefit sought. So that's good. It puts it into law saying, hey, if we approve this guy, the same set of facts, the same petitioner, the same position in the past, we should expect to approve them again and to provide prior deference to this case. Another thing that the government wants to make sure of that it's always happening is to show that that the employee applying for this benefit through the petitioner is indeed maintaining its status, maintaining his or her status in the U.S. by showing pay stubs from the prior pay period to the government. Now, do note, there could be some pushback on this, because what if it's a case where somebody is lawfully employed, but for whatever reason, the company cannot pay them in the prior pay period? The company is having insolvency problems, or some other issue is preventing them from being able to show that they have the ability to actively pay an employee. Well, we don't want the employee to be punished for the fault of the employer if the employee has good faith and is intending to work. We'll see how this plays out. Okay, guys, we've gotten to the point of the discussion that really everybody is waiting for. The dreadful issue of the H-1B registration program. Okay, so we all know what a hot mess the USCIS H-1B registration program is. There's way too many people applying for way too few visas, and it's because there's been a certain gaming of the system where multiple employers are submitting registrations on behalf of the same beneficiary. And it's really, really, really clogging up the system to the point where the selection rate was incredibly low. By the way, you guys, here's a really interesting stat I wanted to read, which is that according to USCIS, registrations for fiscal year 2024 increased largely due to multiple registrations submitted for the same individual. But note, still, due to this low annual H-1B limit of 65,000 plus an additional 20,000 visa numbers, USCIS would have still rejected over 75% of H-1B registrations for fiscal year 2024, even if those beneficiaries with multiple registrations were still excluded from the lottery. And if this doesn't provide commentary on the overwhelming need for Congress to change the annual limit for H's, I don't know, for cap H's, I don't know what does. Okay, but nonetheless, let's get back to the measure of approving H-1B registrations, improving the system for H-1B registrations. So the first thing that it would do is that it would limit registrations to unique beneficiary, meaning that instead of having a system where every registration has an equal chance of selection, they're moving it to a process where every beneficiary has an equal chance of being selected. So instead of being selected by registration, they're being selected by individual. And what that means is that even if somebody is selected, if a person is selected and there were multiple entities that sent registrations on their behalf, that person then has the option to have each of those individuals to go ahead, or those companies to go ahead and file an H-1B petition on their behalf. Now, the government really hasn't clarified how this impacts the overall rule about 65,000 plus an additional 20,000 visa numbers. In my mind, what this says is that multiple individuals could have one individual can still have multiple employers submit H-1B petitions on their behalf, but the thought process is that at least once somebody gets selected, that person then has the agency of self to determine which company they want to actually submit the H-1B petition on their behalf. Which company are they actually serious about working with? And that will help limit the amount of petitions that are submitted thereafter. Okay. And just a few last things here. Another positive change that is proposed here is that they would expand the definition of entities that would become cap exempt. So instead of a more narrow reading of something being a nonprofit research organization, that is primarily engaged in basic research and or applied research, they would then expand the definition to say an organization whose fundamental activity is basic research and applied research. This could lead to an increase in cap-exempt filings, which in turn could potentially decrease the amount of cap filings submitted on an annual basis. And another huge thing for F1 students in particular is that right now, cap gap measures, which basically is a mechanism where if you're a student and your EAD expires between the time your H-1B petition is submitted in October 1st, as it stands right now, the government will automatically extend your work authorization through October 1st of that year, when ostensibly the H-1B status would become activated. Recognizing that we are now having multiple registrations extending past October 1st of a given year, the government has proposed that it will then extend the cap gap period to April 1st of the following year to ensure that individuals have seamless work authorization until the time that their H-1B becomes active. Finally, there have been a lot of students, a lot of individuals who are entrepreneurs over the years who have wanted to apply for an H-1B visa, but because of having to show the employer-employee relationship, it really hasn't been an easy or viable option for them. If they own a company and they want to apply for an H-1B, the government challenges whether you really are an employee of the company or you are the company itself. So recognizing this, the government has created one proposed idea here where they would allow entrepreneurs to file for an H so long as the following is true, that they spend less than 50% of their time managing the business and the majority of their time actually working in the specialty occupation. And if, in fact, that individual is going to be approved, they're only going to be approved for an initial 18-month period, at which point they have to seek to renew their status once more. If you guys stay with me until the very end of this video, good for you. That's a lot of information. I know it's not the most interesting stuff, but it's important and could have wide range lasting effects on the way that H-1Bs are adjudicated. We expect this proposed rule to go through, but we'll just have to continue to to keep you posted and to stay updated on the matter, and we will. Take care, you guys. Have a great day.
Thanks for watching. Be sure to like our video, subscribe to our YouTube channel, and hit that notification button so you never miss one of these important updates. Also, check out the Berardi blog that's on our website at BerardiImmigrationLaw.com. The blog is updated 2 to 3 times a week, contains tons of up-to-date information on policies and trends. You won't want to miss it.